Welcome to the BankTalk podcast, the show where we talk to leaders and experts from the community banking sector. Whether you are a current CEO or aspire to be one, this podcast will give you valuable insights and advice on how to run your financial institution better. Each episode features a different topic and a guest who shares their experience and knowledge with us. Tune in and learn something new with BankTalk podcast.
Hi, and welcome to Bank Talk. I'm Charlie Kelly, your host and partner at Remedy Consulting. Today, we're talking bank enforcement actions. Specifically, prior to a bank failure, what happens to lead up to the failure? Is it always the same process? Something different occur? Is it individual specific to the bank? What are the steps that are being taken prior to a bank failure? Today, I have with me Brendan Clegg. Brendan is a partner at the law firm of Luce Gorman in Washington, D.C., and he happens to be an expert on this bank enforcement action and defending against them specifically, I believe. So without further ado, let's get to Brendan and see what he has to say about this. So welcome back to Bank Talk. Today I have with me Brendan Clegg. Brendan is a partner at Luce Gorman. Brendan, thanks for joining us today.
Thanks for having me, Charlie. Appreciate being on.
Brendan, tell me a little bit about what you do for a living at Luce Gorman. Is it all bank enforcement exam related, or is there? Give me 2 seconds of background if you could.
Sure. So my current practice is a split between enforcement work for banks and their officers and directors, and then more routine regulatory compliant issues that come up in everyday bank operations. But a significant of what I do is handle the enforcement with the federal and state banking agencies primarily.
Brendan, let's start with, because I'm very naive to this process, and I don't know how many of our audience will be the same. Okay with it, could you just define the way you think about, what is a bank enforcement action?
Sure. So a bank enforcement action is typically an agreement that is entered into between a bank or an officer and director and a bank regulator. There are a variety of those types of enforcement actions, the most common of which are referred to as cease and desist orders or written agreements. And they essentially lay out a number of provisions that the bank or an individual will have to comply with over time in order to lift the action. And those provisions are substantive, and they really depend on the findings that preceded the enforcement action being issued. And so in addition to those agreement type of actions, there are also civil monetary penalties, which are essentially fines. And in the case of individuals, they can actually be barred from banking permanently through an order from an agency.
Once an enforcement action is issued, does that mean that the bank can no longer do business? Or they have to hit those criteria in order to continue to operate? Or is there some gray area in between those two?
Yeah, so banks will continue to operate, and how much their operations will be affected really dependent on the substance of the action. So certain of their operations might be significantly limited, or they may be required to get regulatory approval before taking certain steps. Other pieces of their business will continue to go as planned. They may be required to have additional board or management oversight over certain functions. They may be required to partner with third parties to review certain aspects of their operations. It really depends on the facts and circumstances and what the provisions in the agreement lay out. If they're subject to a fine, it's usually the end of the process after the payment of the fine. And then, you more or less get back to a clean slate from an enforcement perspective.
Okay. So generally there's portion, it may not be the entire operation, but it may be portions of the operation where they've sort of violated the regulation, and therefore those are the items that are subject to, and then they use some type of corrective action in between there.
That's right. Now, I will say that some actions can go further than, the scope of the underlying issue. there may be a basis or a supervisory rationale to decide to do something that's larger in scope than the underlying issue. And I think sometimes the bank regulators use that type of more broad remedy in order to solve a concern that they have kind of enterprise-wide at an organization.
So, Brendan, the next question I have is, how does an action start? So is that the result of an exam? Is it multiple exams lead up to one? Is there a pattern? I guess my thought would be the regulators must find out in a pretty common way, right? Exam happens, they identify at that point, or are there other? Can you just give me a feel for how does the process start, before running down the path to an enforcement action?
Sure. So the most typical way for an enforcement action to develop is through the examination process. So the bank examiners will go in their routine examination schedule, and if they discover an issue, they may cite a violation of law or regulation. They may find an unsafe or unsound practice, and that's detailed in supervisory correspondence, which is usually the report of examination. And then from there, for most agencies, what happens is the action can be transferred into legal department within the agency that develops the legal basis for an enforcement action and helps the agency decide on what the appropriate remedy is. But in addition to the examination process, there are a number of other ways that an enforcement action could develop. The agencies have an investigation ability. They can receive a tip or a public finding, press report, a whistleblower report, a referral from another agency, and then use their investigational powers, which include subpoena powers and the equivalent of deposition powers, to develop facts necessary kind of outside of the examination process to bring an enforcement action.
So it doesn't necessarily have to be the result of an exam, because an exam is a scheduled thing, correct? So they can go outside of their normal scheduled exam period if they find something outside the norm or hear of something outside the norm, what have you.
Yeah, they can. And they have a variety of options to kind of get at the underlying issue. It could be they go off cycle and decide to do an examination that's not on the regular frequency, or they could use their subpoena and other legal powers to develop a record that's separate and apart from the examination work.
Okay. So what types of issues lead to an enforcement action? In other words, can you give us some examples of?
So there is a variety of things that can prompt an enforcement action. As you know, banks are subject to a really wide range of laws and regulations, and violation of any of those could prompt an enforcement action. You see those ranging from all aspects of a bank's operation. So you could have something stemming from their compliance with anti-money laundering laws, the Bank Secrecy Act. You could have fair lending issues. More recently, there's been a lot of focus on third-party risk management and how banks deal with their third-party vendors and oversee those. In my experience, especially in the community bank and smaller regional bank areas, there are typically issues that can be found with corporate governance or oversight by board and management. There have been historically a lot of issues with insiders and how they may be engaged in self-dealing or insider lending. Anything that the agencies determine is an unsafe or unsound practice, which is, had a lot of history to that term as a legal matter, but, can still be a little bit in the eye of the beholder, could prompt an enforcement action. And that term, unsafe and unsound practice, can be applied to a wide range of activities that go on within the bank. So that could be noncompliance with their loan policies, or general, good, prudent banking practices, all the way through more risk management or oversight type of responsibilities.
Okay. So it's pretty much the gamut of anything they're regulated around and their internal policies, it sounds like.
That's right. All of those provide the legal basis for an enforcement action for the banking agencies.
I want to talk a little bit because the Silicon Valley thing has been overdone by now a little bit, but I want to talk a little bit about, clearly I think what led up to that was a combination of investments and deposits not being there to cover the investments, that type of thing. But since that time, what's come out of that? I would have thought there'd be trends coming out of the exams or at least what the examiners might be looking for. I think most of the community banks were all worried that this was going to be, just another step in being over-regulated, right? Has anything come to pass, or what are your thoughts since some of those, let's just say since Silicon Valley happened?
We'll be right back.
If you're dealing with a technology vendor, consider giving Remedy Consulting a call. At Remedy, we're dedicated to helping our clients get the most out of their tech spend. If you're considering changing one of your major tech providers or are renewing a contract with a vendor, the Remedy team may be able to add some value. Our clients enjoy our deep experience working inside these major vendors, and that background helps us ask questions which eliminate headaches and expense for our clients. Sometimes that's immediate relief, in the way of your vendor invoices. And sometimes it comes in the form of contract language protection for a strategic move that you may want to make several years later. The group of experts at Remedy have years of experience in core systems, digital, mobile, payments, item capture, commercial banking, pretty much the whole gamut of technology for financial institutions. Remedy approaches the BankTalk podcast the same way we approach our client engagements. We always try to fill some knowledge gaps, but also just have enough life experience stories to remain entertaining. So if you're renewing a technology contract or you have projects going on, just need another opinion or a project manager from outside your organization, reach out to us at remedyconsult.net. Thank you, and we appreciate you downloading the BankTalk podcast. Now let's get back to our episode.
So the interesting thing with bank enforcement actions is that they're long developing. So there is a very lengthy internal process that happens within the agencies where they need to develop the record as a supervisory and then as a legal matter to bring the action. So with something as recent, in terms of agency speed as the bank failures in the spring, a lot of those issues that examiners are now looking out for, and I think, as you pointed out, those have been talked about a lot, but issues related to interest rate risk management, liquidity risk management in general, a lot of those issues are probably coming up and under the microscope for banks for the first time in their next examination cycle following those failures. So some of those issues may be undergoing scrutiny as we speak, and the examiners are preparing the report of examination where they may be taking a tougher stance on those issues than prior to those failures. And what you might see that lead to is publicly enforcement actions that come out, in another 6 or 10 months, say, after that examination, when there has been enough time to kind of process what the results of the exam were, and then let the parties negotiate a mutual resolution. So, I don't think, even though it feels like it's been a long time since those failures, I don't think the absence of a lot of public action, necessarily indicates that the agencies aren't doing things to respond to those. And the other thing to keep in mind is the bank agency enforcement process has a whole aspect that is hidden from public view, where it's part of the confidential record between the bank and the agency. So there might be more informal types of enforcement actions that never are made public, or there may be other supervisory mechanisms that allow the banks to self-correct issues on a timeline that's a little bit more lenient before the bank agencies think that they need to escalate that into something that's public.
Okay, so that I'm going to go on down a little bit of a side path here if you're good with it. The concept of public versus private is really interesting to me. XYZ Bank gets an exam. There's a few things they need to correct. It's not in the enforcement action, right? It hasn't hit that status yet. Most of that, I believe, stays private within the bank. But however, then you get to, Signature and Silicon Valley and some other ones that, clearly are running down a path towards an enforcement and maybe even potentially a shutdown. Is there a line? Like, can you define the line between public and private there, or is that not a definable item? In other words, at what point do I, as a depositor, know that my bank's under scrutiny?
So I think there is a legal line, and then there's kind of, more of a informal line in terms of how examiners view things. So the legal line really is there's a few types of enforcement actions that by statute are made public. Those are the cease and desist and formal agreements that we talked about, civil monetary penalties, and in the case of individuals, prohibition actions. And those, because of the nature of them and because they're provided for by statute, those are made public through the agency publication process. Everything else that happens in the enforcement realm is typically, kept underneath that line, and that is, kept private between the banks and the agencies. How to decide, whether an action becomes the type of formal enforcement action that gets publicized or is more informal, is really a facts and circumstances question, probably, most primarily dependent on the severity of the issue. There are some violations of law or regulation or some practices that are so severe, so widespread or so kind of long running that there's no way that the agency is going to use a non-public mechanism to solve that. There are other issues that, the agencies might feel the banks are able to adequately correct by themselves. They don't need to be made public, and they're given more leeway to do that without resorting to one of those public actions. That, to a large degree, is in the discretion of the examination team in consultation with the legal team. But a lot of it, does have to do with the bank's history of righting the ship on their own, their ability to make changes and respond to supervisory criticism in a beneficial way. And then, I think there is some room for bank counsel to, help negotiate and steer that process, if you can, towards a non-public remedy, relying in large part on the bank's ability to fix that themselves.
Yeah, that's a great response. Because where I was going with that is, and again, this is in your realm more than anything, is at what point then does a bank look for an attorney versus try to solve it themselves, right? Obviously everybody goes through exams on a regular basis, and the majority of those are solvable. But, what's the recommendation and I don't want to say when do your clients call you because they may never call at the right time, right? But what's the recommendation about when they should be picking up the phone to an attorney of their own as compared to, sort of rely on the regulatory attorneys, which are probably, may or may not be working in their favor in something this severe?
So I would say there's really two pieces to that question. The first is when you discover an issue, is it time to call counsel because you may want to consider self-disclosure to the agencies and, whether that will be more advantageous than either letting the agencies discover the issue on their own or potentially, it not surfacing. So, that is a decision that I think is really beneficial to consult with counsel on because they just have more of a breadth of experience with a variety of agencies and issues and can offer some perspective that may be helpful there.
So in that scenario, you're thinking that is we've discovered something internally, maybe hasn't gotten to an exam yet, right? The exam's coming up in November or something, or right, it's coming up 6 months from now. That would be the scenario. There would be, we've discovered something internally that just feels wrong that I'm sure the examiners are going to have a problem with. So then the decision as to whether to go to the regulators and have a discussion with them ahead of time. Am I thinking about that right, or did I get that wrong?
No, that's exactly right. So internal audit finds something, or a compliance person realizes an issue, and you do a little bit of an internal investigation or digging, and you find out kind of the cause of it, get an understanding of how widespread it is, and then you have to make that decision. Are you going to go ahead and self-disclose, or are you going to try to correct the issue on your own and deal with it that way? That is probably the first time that you need to consider whether counsel should be consulted.
The other scenarios.
Yeah, so the other piece I would say is typically when you get an exam report or other supervisory correspondence, and you either have your ratings have been downgraded, heavy language in there that's suggesting that the bank agencies are no longer completely confident in management or the board's ability to oversee the bank. They've cited violations of laws or regulations or alleged unsafe or unsound practices. I mean, all of those things I think warrant a check-in with counsel, and not to, self-aggrandize our own role. But I think, we would be helpful in identifying to bank clients the type of language that suggests that the agencies have either initiated or considering initiating an enforcement process. And some of that is just, how the tone of the letter in general. Some of it may be specific citations to laws or regulations that are enforcement related. And those types of things, a careful lawyer who's practiced in this space a lot can pick out of an exam report and, help tell a client, we think that this is something that is going to proceed down the enforcement path. Let's start getting prepared for that. Or, this seems to be more just run-of-the-mill supervisory commentary, and, we're happy to help share our insights on how to fix this, but this is typically in the bank realm for how to respond to, their examiners.
Okay, so we had another conversation on BankTalk quite a few months ago with one of your counterparts, Kip Weissman, and we were talking about governance, board governance, and specifically. So are individual directors and officers at risk for the, when an enforcement action comes up? Are they, does the board become at risk? The management team, some combination? I mean, can you give us a little experience there?
Yeah, so the answer to that is yes. If you go to any of the bank agency websites, you'll see plenty of enforcement actions taken against individual directors and officers, and there are also, more general board-wide actions. So typically, the case may be brought against an individual officer or director for something that's specific to their own conduct. They've engaged in insider lending that's prohibited, or committed other unsafe or unsound practices. So those individuals can be the focus of an action, but the agencies also occasionally look at, on a more general level, whether there was a failure of senior management or board oversight in failing to assess the risk, to identify the risk, take sufficient action to curb the risk, or to prevent some misconduct from happening. And there you may see an enforcement action against certain members of the board or management who are specifically involved, or, at times there may be a general civil money penalty or other, lower level enforcement action against the entire board of directors for what the agencies see as, a failure of oversight.
You're saying that each of the directors in a scenario like that might have the ability to get a fine outside of the bank itself.
Yes. So each of the directors could be subject to a civil money penalty for more of a general allegation against the board as a whole for failing to take, sufficient oversight actions.
Gotcha. All right. Well, I think that's the majority of what I wanted to talk about today. One more question, right? So when you get into these enforcement actions, what are the actions that most trip up a bank, or trip up the board, or trip up whomever is responsible for fixing the problem?
So I'd give you a few things, Charlie. The first thing I would say is to identify conflict. So, one of the first things as an enforcement counsel that you want to evaluate is whether the actions of management and the board, whether or not those are in alignment and whether their interests are in alignment, or whether certain of those individuals on management or the board may have diverging interests because some of them, may be target enforcement action and others may not be. And in those cases, you need to evaluate whether certain of those individuals should have separate counsel or whether it's appropriate for the bank's counsel to represent, more than one individual or group of individuals. Another major thing that trips banks up relates to the sharing of supervisory information. So as you may know, the bank agencies take the concept of CSI really seriously and, without their authorization, prevent banks and their employees from sharing agency conclusions or correspondence outside of the bank. And there are really nuanced rules around who you can share it with and when. And so you see, a lot of times there may be a desire to share that information with consultants who are brought in to help with an action, or you may need to share it with insurance carriers to figure out who's paying for the legal fees for these actions, or you may want to share it with affiliates. And the rules are very prescriptive. And, if you don't follow them and get the proper authorization, you may find yourself in even hotter water than just the underlying action.
Yeah, I never would have thought of that.
The last one I'd say is more of a legal issue too. It's related to attorney-client privilege. There can be a lot of voices in the room. Some of those people, may be the clients of counsel. Some of them may not be. There may be, say, shareholders of the bank who don't have any actual ability to get attorney-client privileged information. There may be third parties that have relationships but aren't covered by privilege. And people at the bank might be most interested in trying to resolve the issue as quickly as possible and getting the right people in the room, and they may inadvertently include people in communications of privileged conversations who aren't entitled to it and aren't covered by the privilege. And that could end up, becoming relevant down the road in not just the bank enforcement context, but, you can often see disclosure issues in later derivative suits or shareholder suits where there's a question of whether the attorney-client privilege was broken.
That's interesting. Very interesting. So, Brendan, is there anything else we want to talk about here before we conclude? Anything else that listeners might not know about this process?
Yeah, I think we covered the basics. I would just say, the bank enforcement process is this weird world that exists between, true litigation and, the administrative agencies. Has its own rules and unique nuances. And I found it to be a very interesting space, and one that's, full of questions and, really unique aspects that you don't get to find in other areas of legal practice. But it's an important consideration to keep in mind for banks and their officers and directors that you are in this unique process where the rules are written by the agencies, enforced by the agencies, just kind of underscoring the value of knowing what those rules are or who to call to evaluate those rules, once you get into trouble.
So, Brendan, I'm going to ask you one last question. And can I ask you how subjective this is? Right? Because I would think even in an exam process, oftentimes a bank will come back and go, boy, I got written up for something that I didn't get written up for before, right? Or I got written up with a different examiner. So I'm sure there's some subjectivity to just the exam process, but does it tighten itself up as it gets closer to enforcement action? Like when it becomes more serious, is there more oversight to it to make it a little less subjective?
Yeah, there is. And, I've been on both sides of this. I was at the OCC at the beginning of my career in the enforcement division there. And, having been in private practice for a while now, doing this on the other side, I would agree with you generally that there can be a lot of subjectivity to a lot of this. The agencies view similar rules differently. They interpret similar issues differently. Even different regions within the same agency may take a different approach. Different people who head different parts of the agency, once that personnel change is over, there may be a change in interpretation there. So I would agree with you there, but I will say, the role of the legal department within each of these agencies really is to help standardize the actions, over time, and to ensure that the agencies are applying the same rules for the most part, consistently, to banks, whether they're small or large, whether they're located in a different geographic region or not. I think their role is to help see that kind of nationwide viewpoint that individual examiners, they may just not have that window or ability to do. They're just focused on the institution they're examining. So I would say, while there is some possibility for that, and that's, really why I think it's valuable to have an attorney help push back where it's warranted and, find those points where you can really dig in, the agencies do have their own built-in mechanism to be able to do that too.
Okay. Yeah, and that's good. That's important, right? Obviously, you need some oversight at a higher level when it gets to become, that serious enough that it's going to be made public, et cetera, I suppose. So.
Exactly. Yeah.
Okay, Brennan. Well, thank you very much. I appreciate you joining us here on Bank Talk, and really appreciate your opinion on this. As I said before we started, an area I didn't know very, very much about, and I think a lot of what you put together here just clarified some things for me. So thanks for joining us again.
Yeah, thanks for having me on. It was great.
So that's all for Bank Talk. I appreciate everybody listening today. Make sure you have a good day and keep on learning.
Thank you for listening to the Bank Talk podcast, brought to you by Remedy Consulting. For more information on this topic, reach out to Brendan at bclegg@luselaw.com. Once again, bclegg@luselaw.com. And or you can go to the Luce Gorman website, which is luselaw.com. Thanks again, and we will see you in the next episode in 2024.